And because of the technology advances, the USA Assembly is now losing its market to the Asian competitors. And so the USA Assembly has a US patent which covers its equipment. And so that is the complainant's side. Now, as for the respondent, the Seoul Equipment Company has developed a more advanced second-generation assembly equipment. And they manufacture the assembly equipment in Korea. They sell it to the US. And the USA Assembly, which is a patent holder, says that the second-generation assembly equipment is infringing upon their patent. So that's the whole story for this case. We have the judge, administrative law judge, Essex, and the complainant is the owner of the patent rights. The respondent is the manufacturer who sells the products. And also, although we do not have him here, there will be a neutral person, the ITC staff attorney, who will be consulting the judge. Now, let's say if I was the attorney for the respondent, if the staff attorney's consultations are to our interest, that's no problem. But because the staff attorney is at a neutral position, will the judge really take that view? It's not always the case, because Judge Essex has his own opinion, and he would not agree to the opinions of the ITC staff attorney at all times. And also there's going to be the witness, and at all times during a trial we have the court reporter with us. I want to ask the Korean case. Do you have this as well in Korea? In the US, during a trial, when anyone speaks anything, everything is reported by the court reporter. And so simply with the court reports, we will deal with the reports of the court, even jokes or asides. Everything is recorded by the court reporter. And these days, the court reporter has direct access to the computer, so we have immediate transcripts of the trial itself. And also in the ITC trial, the judge will make the determination himself. We have no jury. And as was mentioned, the determination by the administrative law judge, it could be agreed, and that's going to be the final determination, or else it can be reversed. But any cases which are reversed in about 10 years, there are very few, because the Commission will either agree or reject the determination. So that is different from the other court cases. In the case of ITC, the Commission, once they make the final determination, if you want to appeal, the case will go to the Federal Circuit. And so these are the participants of our mock trial today. We have Judge Theodore Essex, and also for the patent holder, USA Assembly, the attorney for the complainant will be Mr. Tom Jarvis. Also, the attorney for the respondent, Seoul Equipment, will be Esther Lim. And Esther Lim is a lawyer for the respondent. She's a good guy, and Tom Jarvis is a bad guy here. And also Charles Saw is going to be the fact witness. He will be providing us testimony about the fact itself. And we also have Stephen Park, who is also going to be the expert witness, the technical expert witness, and he will provide us with his testimony, expert testimony as well. And we are going to rearrange the seating arrangements as well for the trial. And as for the trial, each lawyer representing each side will give us the opening arguments. First, we will have the lawyer from the complainant, and the opening arguments must be persuasive so that the judge can understand their claims. And after that, the lawyer for the respondent will also give us the opening arguments. And then we will hear from the fact witness. When we talk about the fact witness, the respondent has a prior art info act within the patent. The Info Act already has the facts of the patent itself. So that's going to be what the fact witness is going to tell us. So Charles Saw is going to give us his testimony. And then during the cross-exam, lawyer for the complainant is going to cross his testimony. He's going to rebuttal of the testimony of the fact witness. He's going to refute the published data. And then at that time, Judge Essex is going to rule on the evidence itself. And then after that, there's going to be the testimony of the expert witness. The expert witness for the respondent is going to, we're only going to listen to the expert witness from the respondent. He's going to claim that the patent is invalid, that the equipment from Seoul Equipment did not infringe upon any patent. That's going to be his testimony. And then after that, there will be the closing arguments from both lawyers. They are going to make conclusions about their own claims. And the complainant lawyer is going to go first. He's going to make his closing arguments, which is very important. And the respondent's lawyer also will give her closing arguments. This is a mock trial, and after hearing all the arguments, the audience will vote on the outcome, because this is a mock trial. Whether you think the claims of the complainant is right or whether you think that the claims of the respondent is right, we're going to have a vote. And then after that, of course, our administrative law judge will give the final ruling. And I'm not sure whether he's going to take into account the vote results, whether he will see the results of the vote or not. I'm not sure how it's going to go. So that's our plan. And we have a coffee break planned at 3 o'clock. So this is a brief summary of the mock trial itself. We had originally planned to provide you with some explanations during the mock trial, but because I think I've made most of the explanations and the procedures have been made clear, I'm not going to interrupt the mock trial. Rather, we will be going through the mock trial as it is. First, we'll hear the opening arguments, hear the testimony of the witnesses, and the judge's rule on the evidence, and then the expert witness and closing arguments. After that, we're going to have the Q&A, and then the reception organized by KEA. Thank you.
It would cost us a lot if we were to go to the US and actually try this, but